Hey guys, welcome back. Today's courtroom footage turns into absolute chaos from the very beginning. Three sovereign citizens walk into court believing they can outsmart the system, but within moments, tensions explode and the entire room is thrown into confusion. Leading off is a familiar face some of you may already remember, Michael Stanley. After his last courtroom appearance ended in disaster, he's now back with a brand new update, and somehow things spiral even further out of control this time around. Arguments erupt, patience runs thin, and the judges are left stunned by what unfolds right in front of them. These courtroom moments are unpredictable, intense, and packed with confrontations you genuinely have to see to believe. Stay tuned, because each case becomes more shocking than the last.
Okay, we're on the record now for 25 CR 745, People versus Michael Stanley. Mr. Stanley, I see you on WebEx. Can you hear me? Hold on, we have to unmute you.
Sorry, yes.
All right. So we're here. You would wanted to enter a not guilty plea and set for trial. However, I did state you have to be in person to do that, and you have to be in person anyway, but that you have to be in person, especially if you have any other warrants. And I saw that you still do. What is going on? Where are you?
Okay. I do want to let the court know that I did relocate to Laramie from Pinedale to be closer to Colorado. And I'm in a rental assistance office right now. And I'm sorry, it just so happened to land at the same time. So I'm trying to juggle both things at the same time. Yeah, that's where I'm at. And I apologize for not being able to be there in person. I just don't have the funds to make it now. And that's why I'm here, because I took on $1,200 rental agreement. And I'm trying to make sure that I don't lose it. And in regards, I don't know. I know that the lower court had a 25th meeting, and I'm not sure if there was a warrant put out or what is going on. Since I did change addresses, I have had no correspondence since I left Pinedale. I did do a change of address though.
Did you file that in the case?
No, sir. I'm sorry. I did that at the post office. This has just happened recently. I've only been here a few weeks.
People?
Well, Judge, he has a warrant out of F25M603. They're based on a failure to appear. It looks like he has been appeared by WebEx back in December, was told he needed to be there. There was a show cause hearing on March 25th that he failed to appear at also, so his bond judgment entered on that bond.
This has been an ongoing thing.
Mr. Stanley, hold on, I'm not done. So there is no open...
I'm sorry, it's going in and out.
There's no next court date in the misdemeanor case because of the failure to appear. At this point, Judge, given the number of times we have been doing this where he's been trying to appear by WebEx, it frankly looks like he's just trying to avoid dealing with that misdemeanor warrant. So my request is that the court find that there's been a failure to appear given the number of times he's been told to appear in person, and to issue a warrant in this case for his arrest.
I object to that because I don't think that's appropriate. The only reason I'm not showing up down there, and I did show up down there once before only to get arrested, is I'm not trying to lose my place to stay and sit here and keep trying to bail myself out when I'm not willfully violating conditions of my bond. If this would be simply consolidated and handled in the district court, as I've been putting you guys on notice about this, it wouldn't be a problem. I'd be there every time. I can't, you guys want me to come there week after week. It's not economically viable. I used to live 6-7 hours away. You guys want me to come on the 25th, the 2nd, the 7th? I mean, this has been an ongoing thing. So you cannot create like undue hardships and go against my constitutional right to travel, which he gave me permission to do, by the way, and then have a lower court fighting the upper court. This makes no sense. I'm not the one doing this. Let's put that in perspective really quick.
Of course, somehow, the blame always shifts to everyone else the moment someone decides their so-called right to travel gives them the authority to operate a motor vehicle without a valid driver's license. But that argument falls apart the second it's tested against actual law or basic reality. Courts have heard these claims countless times, and they consistently reject them because driving on public roads is legally treated as a regulated activity, not an unrestricted personal entitlement. In the end, this isn't about government oppression or a broken system, it's about a complete misunderstanding of the law. And when that misunderstanding collides with real legal consequences, the situation quickly turns into a self-created problem that no courtroom is willing to excuse.
Judge, he's the one not showing up to court. So my request
I'll
on
be
this
there.
one
I'll
is that
be there tomorrow.
the court issue
I'll be
a
there
warrant
tomorrow.
on this
I'll be
case.
there
He's
tomorrow.
been
hold on.
told multiple times to appear in person. He has not. So my request is for a warrant on this case.
It has nothing to do with this court. That's not
Hold
why I'm
on.
not appearing.
It's enough. So what we had is I issued an order. I issued an order in this case that we didn't issue a warrant for him last time he appeared on WebEx, and the order I issued indicated, because he wanted to set this matter for trial, that he was reminded to appear in person to enter a plea and cannot appear remotely if there's an outstanding warrant, and he indicated he was going to get that worked out. It's not worked out. And so we have a situation now where I put that out. That went out March 5th. That was almost a month ago. And it was approving WebEx virtually for that last hearing, which was done, but with the reminder that any plea or if there is a warrant requires in person. It's not my warrant, but it's a warrant. And that is clearly spelled out in this now month-old order. So I don't think it's a matter of no advance notice. The court finds that it's appropriate, the people's request is granted, and we'll set this matter when there is a cancellation of that warrant.
Well, if I filed that habeas, I don't know the proper procedure to try to get this thing quashed or otherwise move forward without continuously having to get arrested.
Happy to look at any motions that may come in. I'm happy to look at them, but the order was clear.
Well,
the order was issued.
It was my understanding that I had to get it alleviated through the party or otherwise the judge in question, which is it's this constant battle between me and him. I don't know what. And now that I've asked,
I don't get to set his warrants.
I don't get to. You got to remember, I've got.
Sir, I don't get to set his warrants. I told you that last time.
Yeah.
But what I am here for is I had an order saying that you need to be here in person if you had a warrant or if you wanted to set this for hearing, for trial. Whether you set it for trial doesn't matter because you have a warrant, which means you need to be here. So that's a rule that's building wide. That's not just a me or a him thing. That's if you have a warrant, you're not allowed to appear virtually. I made that very clear on March 5th, and that's the way we have to stick with it. I'm not the one who chose to schedule something at the same time. So we're going to go ahead and give the people what they asked for, and we'll be in recess.
So what does that mean now?
That means you essentially, for purposes of this order that put you on notice, you failed to appear. And you will now.
And you're recording now.
Yep. And you will now have 2 warrants.
Wonderful.
All right. We're in recess.
So you guys are going to make me homeless. Is what you're trying to do. Okay. That's cool. I appreciate it.
Maybe this entire situation could have played out very differently if the warrant had been handled when you originally promised the court you would take care of it after your previous appearance. During the earlier hearings, the instructions were made crystal clear: you were expected to appear in person for the next court date. But instead of following through and resolving the matter directly, the situation was allowed to spiral further. Delays, missed appearances, and avoiding the issue only pushed the case deeper into legal trouble, ultimately landing you right back in court again, this time in an entirely different courtroom facing even more consequences. What could have been a manageable situation turned into another unnecessary legal setback simply because the original responsibility was never properly addressed. And with that case now behind us, let's move on to the next courtroom moment.
I'm sorry, sir, who are you?
My name is Dustin Anthony of the House of Kaminsky.
I see. Thank you, Mr. Kaminsky.
I apologize, my clippers died halfway through a haircut. I could put my hat on if it pleases the court.
It's okay. Thank you.
Right.
I'm just happy that you appeared. Court will recall 26 CR6. People v. Dustin Kaminsky. He was on a PR bond and appears. the this case will be set for filing of charges, were charges filed? Thank you. Did you have you received the charges? Nope. Okay, give us just.
I don't think charges were filed on this one.
Okay.
Whoever made the case didn't find them, so it looks filed.
Oh, okay. So there will be some filing of charges. That will be next Tuesday, March 24th. So you'll have to come back here March 24th at 1:30 here at the jail, okay?
Okay.
And then the district attorney's office will, because at this point you are accused of a crime, you were arrested, but then the district attorney's office has to file the official charges against you.
Okay.
And so you'll need to return back here March 24th at 1:30, and you'll remain on bond, and unless you fail to appear, then that bond could be revoked. So that's the paperwork, and you'll need to come back for the filing of charges. And then if you are looking to have the public defender's office represent you, you'll have to apply for their services, okay?
Okay, so since the files haven't been, charges haven't been filed yet, I can't inquire against what the nature and cause of the case against me is?
Well, you were arrested on January 2nd. 2026, and so that's what the charges arose out of.
Okay, is this a criminal court or is this a civil matter?
This is a criminal matter.
Okay, I'm here by special appearance. I'd like to challenge, subject matter jurisdiction and personal jurisdiction.
Yeah, this isn't the time to do that.
Okay, that's why I asked about, this filing of charges yet.
Yes, and so we will address that, but not at this time.
Okay, and that was the 26th at what time?
No, it's the 24th, March 24th at 1:30.
Okay.
Yep.
Take your time, thank you.
And the piece of paper that you have has that date on it. Do you see it?
This could help.
Yeah, go ahead. Why don't you put your glasses on, and why don't you repeat that date to me?
Yes, March 24th at 1:30 p.m.
Okay, thank you. We'll see you back here at that date and time.
Have a good afternoon.
Thank you, you too.
That hearing may have been brief, but the story was far from over. To his credit, he did appear in court on the 24th of last month, and at that time, the charges against him were eventually dismissed. For a moment, it looked like the situation might finally be behind him. But despite having those charges dropped, he was still under probation requirements, and that's where things started to unravel again. When the time came for his revocation hearing, he failed to appear in court altogether. That single decision immediately intensified the situation, triggering another arrest and pulling several others tied to the house of Kaminsky into the growing legal fallout. What initially seemed like a resolved case quickly turned into yet another courtroom setback.
That's 23 CR 5243, People versus Dustin Kaminsky. Can you hear me, Mr. Kaminsky?
I'm also hard of hearing, but I can hear you, sir.
Okay. All right. Can I have entries?
I'm Dustin Anthony of the House of Kaminsky. I'm here by special appearance to challenge both personal and subject matter jurisdiction.
It looks like you're represented by the public defender. Is that right?
He was at one time, Your Honor. If he wants counsel to be appointed, we can enter today. This would be my first time actually appearing with him if he wants a public defender.
So, Mr. Kaminsky, because you're in custody, you have a right to a public defender if you want one. Would you like me to appoint the public defender?
I can speak for myself, Your Honor, but any help would be also acceptable.
Okay.
I guess then that sounds like a yes. So I will go ahead. And are you Miss Barton?
I'm Camille Taylor.
Oh, okay.
Bar number 48054.
Okay, thank you. And for the people?
Lindsay Maas for the people, Your Honor, attorney registration number 49996.
Okay. And would then this be your case, Ms. Taylor?
It would be, Your Honor.
All right. I will appoint Ms. Taylor on this case. Looks like, is this a first appearance on an arrest warrant?
This is a revocation of probation matter. It looks like we need to set bond. It was previously set at $450 cash back in 2024. So, but since he's been arrested this time, we don't have a bond set.
Okay. Would you like to be heard on bond?
Yes, please. Given that the prior bond was a cash bond in the amount of $450, I would ask for a slight increase to $475 cash.
Okay.
I would ask for a PR bond, Your Honor. I don't have any cash on me.
Okay.
Alternatively, a PR.
So, Mr. Kaminsky, here's the thing. If you have the public defender representing you, they speak for you. Okay?
Well, then I can speak for myself, Your Honor.
So not only are you deaf, but you're also dumb.
Okay. Well, let's hear from the people.
Thank you, Your Honor. The people are recommending a $600 cash-only bond. We'd note for the court that Mr. Kaminsky was initially on a probation revocation summons. He showed up for his first court date several hours late, avoiding a warrant at that point. He failed to appear at his next appearance, and it would seem that while on failure to appear status, Mr. Kaminsky has picked up an additional felony case in Boulder County. We do believe that the increased cash bond value is appropriate based on the failure to appear as well as the other records made by the people. Thank you, Your Honor.
Your Honor, that felony case out of Boulder County was dismissed, and they also entered a motion to quash the record, the arrest record, and it was signed by the judge in Boulder County.
Okay. Well,
So there is
no.
no felony case out of Boulder County at this time, sir.
All right. Even assuming that that is true, I'm going to find, based on the failures to appear in the history of this case, that a cash bond is appropriate. I'm going to set bond at $500 cash only, with all original terms and conditions.
And Your Honor, how can this be a court of record, a criminal case, if there is no verified complaint by a living injured party?
According to the verified complaint filed by the probation department, the issue goes far beyond simply missing a court date. The report states that you failed to appear for your scheduled revocation hearing while also becoming involved in additional criminal charges during your probation period. And although those separate charges were eventually dismissed, that alone does not automatically erase the probation concerns tied to the incident. One of the most fundamental conditions of probation is the requirement to stay out of further legal trouble and avoid conduct that could violate the terms of your release. By allegedly breaking those conditions, the court now views the matter as a direct breach of the agreement you accepted when probation was granted. That violation is exactly why the case has resurfaced and why you are once again standing before the court facing renewed legal consequences.
Okay, there's been a complaint filed by the probation department. I find that that's appropriate, and that this is a court of record for that purpose.
And then, Mr. Kaminsky, you have the right to a revocation hearing within 14 days of today if you want to set immediately. That would be an evidentiary hearing where the prosecutor would have the burden to prove that it's more likely than not that you didn't comply with your probation. So you could set that today immediately, and the judge would have a 14-day timeline in which to hold that hearing. Otherwise, you could waive the 14 days and set that hearing literally any time, whether you're in custody or out. I would rather meet with you to discuss the allegations before we set a hearing, which would require you to waive the 14 days. Are you okay with taking that approach?
I don't have the $500 cash on hand, so I'd rather just take care of this right now.
We can't, either way, we're not taking care of this today just because I haven't talked to the DA about a plea offer, and I don't even have a copy of the complaint against you.
Okay, so I completed treatment, I completed the class that was required.
Mr. Kaminsky, don't talk about the facts. So I'm going to chat with him if that's okay, counsel.
That's fine.
So, Mr. Kaminsky, as your attorney told you, you have a right to a hearing on the complaint. Because you're in custody, you have a right to that hearing within 14 days. If that's what you want, we will set a hearing for you. Your attorney would like some time to talk to you and see if she can reach an agreement with the DA. That may take more than 14 days, and that's how this is typically handled. If you want her to try to do that, you would have to waive your right to a hearing within 14 days. We'd set a status conference at a time that the attorneys agree to, and if you're not able to reach an agreement then, we would set a hearing. So do you want
I don't see why my attorney couldn't handle this within 14 days and review the evidence and also review with the district attorney. I'm going to be sitting here since I don't have bond. Would the court consider a PR bond?
No, I wouldn't.
I would be able to prepare better for
Mr.
this
Kaminsky,
case.
you need to let me talk now. I'm going to find that he's not willing to waive his right to a hearing within 14 days. We will set a hearing. If the attorneys are able to work something out prior to that hearing, that's great. But if not, we'll give you your hearing within 14 days, okay? Can we get a date?
How long do you need?
Can we please have an hour, 45 minutes?
I can do August 8th at 2.
August?
Or, I'm sorry, April 8th at 2.
Does that work for council?
April 8th at 2. That'll be fine.
We can accept that, Your Honor.
All right, so Mr. Kaminsky, your hearing is going to be April 8th. That's a week from now, more or less, at 2 o'clock. Your attorney will, I'm sure, try to be in touch with you before that to talk to you about your options and to prepare for a hearing if there's going to be a hearing. Okay?
Okay.
All right, thank you.
Have a good morning.
You too.
That officially brings the second defendant's hearing to a close, for now. Another court appearance has already been scheduled just a few days from now, meaning this case may take yet another turn before the week is over, depending on what happens next inside the courtroom. But as that situation continues to develop, this next case involves an in-custody sovereign citizen who is far from a stranger to the judge presiding over the matter. With a history already established between the two sides, the atmosphere in the courtroom is immediately tense, setting up what could become another dramatic and highly confrontational exchange before the hearing is over.
Mr. Leau?
Yes, Your Honor.
Mr. Leau, good afternoon again.
Good afternoon. How's it going?
It's going well, thank you. I wasn't hoping to see you so soon again. I gotta tell you.
Things happen.
I know it happens, I know. I just was hoping for a time where you and I, not that I mind seeing you, I just wanted you to have some space, you know what I mean? So the case is 26 CR 388. Comes on for an advisement. The court does find probable cause. Regarding the bond, Mr. Leau, let me hear from the attorneys. Ms. Cunningham?
Judge, we will be requesting a personal recognizance bond with the appropriate conditions. That is what is recommended in the bond application. So we think that is appropriate here, and also given the nature of the charges, it appears to be a lower level felony if I had to guess.
You don't have to guess. DA, bond.
Your Honor, I am asking for a $5,000 cash or surety bond. I recognize that this isn't, a super aggravated felony case, but I'm definitely concerned about his ability to comply in the community and to return to court. It looks like he has 8 failures to appear in the last 4 years, most recently being 2 weeks ago in the case that he's currently on probation for. So those are my concerns, and I think a secured bond is appropriate.
Your Honor, may I have word?
If you want one, I can tell you this, your attorney probably doesn't want you to speak, but I promise you I'm not going to stop you if you want to talk briefly.
Well, just directed towards the district attorney. I'm part of the Oklahoma Sioux Tribe, which with Medicine and Wheel Coalition is a coalition with the People's Republic in Boulder County.
Mr.
I know, we've talked about that. You and I have talked about that in my courtroom. I know that.
If they haven't contacted President Starr, comes out, or President Dolan Wood and I, why wouldn't I be released back in the community? Because honestly, I'm immune. I'm sovereign. I'm a sovereign citizen.
I got you.
So I don't even know why. I already have hostage and ransom insurance on this claim right now.
I got you.
The incident that happened, I own Wells Fargo. My grandpa's the owner of Wells Fargo.
I got you, Mr. Leau, and I've heard some of those things, not all of those, but some of those before. And while I do want you to speak, if you want to speak, I got to tell you straight up, it's not helping the case right now. It's not a useful thing right now. You know what I mean? I'm going to set bond as follows: $5,000 cash or surety. Conditions: no contact with alleged victim. Pretrial supervision via CJS. Report to your Boulder County probation officer within 24 hours of bonding out. No drugs, no weapons. Stay away from 1801 13th Street, Boulder. Filing of charges Friday, April 3, 1:30 p.m. Right back here. We'll see what charges the DA chooses to file, if any, in the case. Thank you, Mr. Leau. We'll see you in 2 days.
At the end of the day, it all comes down to choices and the consequences that follow. If the claims being made were accurate, and clearly, they don't align with the record, then posting a relatively small $500 bond wouldn't have been an issue. Yet despite having that opportunity, the defendant still failed to appear at the scheduled hearing this past Friday, a development that, for those familiar with the case, was hardly unexpected. No clear explanation was provided for the absence, and instead of moving the matter forward, it simply resulted in yet another court date being set. As for this case, I'll continue to monitor any further developments along with the others previously covered. Now, we move on to our next and final hearing of the day.
Court calls cause number 2019-3244 and 6278, Tony Orosco. Announcement of council, please.
David Nunez for the state, Your Honor. State is ready.
And Daniel Avila for Mr. Orozco, Judge.
Mr. Avelar, he has an active warrant, is what my docket said. You know
I
that?
saw that. I saw that, Your Honor.
Okay, he's got an active warrant, so I guess, did you talk to him recently? Have you talked to him?
I do. I filed a motion to cut me loose, Your Honor. This is the case, Judge, where we had court last month sometime. He was tardy.
Shirtless?
You guys got into it.
Was this
And
the
then-
shirtless guy, the guy without the shirt?
No, Your Honor.
No, Judge, no, he's not the one.
You gave him a 6-day commitment, and he said straight up, "I'm not gonna do that."
Oh, I remember.
Straight up, I'm not gonna turn myself in.
I remember that.
I called him after that. I said, "Hey, listen, just take care of it. Do what you got to do."
Yeah, like you did with Ms. Martinez, and I appreciate that.
Right. He gave me the same answer. I'm not gonna do it.
Okay.
I thought he would eventually come around. He hasn't. We made contact with him yesterday or this morning. Please show up to court. He hasn't. I'm asking this court, maybe we can set it for a hearing on withdrawal.
Okay, let's do that.
I think
The judge calls the case, and both attorneys step forward, but the atmosphere tightens almost instantly when an active warrant is brought up. What began as a routine hearing quickly shifts into something far more serious. The defendant's previous refusal to comply is now back in focus, casting a shadow over the proceedings and raising the stakes in the courtroom as the situation begins to escalate under mounting legal pressure.
our communication has broken down.
It has deteriorated. I think so too. Okay, and this man needs a little bit of jail therapy, I think. Okay, set this up for a motion to withdraw, whenever we can, Becky, next week on a Thursday, or Wednesday next week, or the following week. I mean, if he gets arrested, okay. Go ahead and file your motion on that, Mr. Avelar. Thank you, sir. Did you have another one, Mr. Avelar?
I don't, Your Honor.
Thank you, sir. Thank
Thanks
you.
very much.
You tried. 1 out of 2 ain't bad. You got Miss Martinez in, and I thank you for
Right.
that.
Yes, ma'am.
This woman did over and above and beyond what I thought she was going to do, which was turn herself in, get the device, do all of that like in 2 seconds, which she should have done in the first place.
Right.
But
Right.
anyway,
Tomorrow we're gonna have a case where somebody just completely went like this to you. You'll hear it tomorrow.
Oh my!
You'll hear it tomorrow. You're gonna hear it
They threw the finger to the court
like
stories.
this. Right.
I'm
That
not
one's
very-
gonna be fun tomorrow, Your Honor.
Thank you for the warning, Mr. Avelar.
Right. Yes, ma'am.
The next one is Tony Orosco. This is on a motion to withdraw. Do we need to get on the record on this one, Mr. Avelar?
Please, Your Honor.
Okay, at this time.
Please, Your Honor.
Okay, sir. 2019 3244 and 6278. Tony Orosco. Announcement of council, please.
David Nunez for the state, Your Honor. Stage is ready.
And Daniel Avelar for Tony Orosco, Judge.
Okay,
Who
Mr.
I think I see on.
Oh, you do see him, Mr.
I
Orozco?
think he's present. Yes, I see.
Yeah,
him.
he's on mute.
Yeah, there he is. Mr. Orozco, can you talk to me, sir? Mr. Orozco?
Yes.
Okay, Mr. Orozco, how are you today?
Yes. Fine.
I'm sorry?
And yourself?
I'm
I
good.
said, finding yourself?
I'm good. Was this the shirtless guy from previous? He doesn't have a shirt on. Why don't you have a shirt on, Mr.
I'm sorry?
Orozco? Why don't you have a shirt on?
Because I'm getting dressed for right now for work in the middle of this. I just got getting dressed.
Would you show up like that in court, sir? To court?
I'm sorry?
Would you show up the way?
No, it wouldn't be on my phone if I showed up in court. And my name just came up right now, so I was getting dressed for work. I'm sorry.
Where do you work, sir?
Huh? I work at a gas station, Valeros.
Okay, sir, I want you to shut your screen. I want you to put a shirt on and come back. I'm not gonna have you shirtless. Shut your screen. Okay. Okay, you had another one?
I do, Judge.
We are back with Mr. Tony Orozco. Court calls cause number 2019-3244, 2019-6278. Announcement of council, please.
Alright, guys, this is where the courtroom scene takes an unexpected shift. The defendant appears on screen, but the judge immediately notices he is not properly dressed for court, appearing without a shirt. The exchange that follows is direct and unfiltered, as excuses about getting ready for work are quickly dismissed. The judge cuts through it firmly, ordering him to correct his appearance before the hearing can proceed, reinforcing strict courtroom discipline and control.
David Nunez for the state, Your Honor. Stage is ready.
And Daniel Avelar for Roberto. Oh, I'm sorry, Judge. I apologize.
For Tony Orozco.
For Tony Orosco. Yes, ma'am.
Very good. Mr. Orozco, are you there, sir?
Yes, I am.
Okay, sir. Mr. Orozco, do you see and recognize your attorney? Mr. Orozco, are you there?
Yes, right here.
Okay, sir. Do you see and recognize? Why do you keep looking back, Mr. Orozco? You do this all the time. You've done this 4 times already. Who are you looking back at?
Nobody.
Okay, you keep looking back.
Nobody.
Okay. Mr. Orozco, do you see and recognize your attorney, Mr. Avelar?
Yes.
And Mr. Avelar, do you see and recognize Mr. Orozco as the defendant in this case?
I do, Your Honor. Yes, ma'am.
The record reflects that both have identified each other. Okay. You want a motion to, was this the one that you wanted to withdraw, but then you withdrew your withdrawal and now we're back again for another withdrawal?
No, it's
Somebody else. Okay.
somebody else.
Okay. So you want to withdraw or Mr. Orozco wants you to withdraw, Mr. Avelar?
It's on our end. I don't know that Mr. Orozco wants me to necessarily withdraw, but the counsel needs a withdrawal on this case. If the court should
Okay.
be gracious enough to grant
If I allow you to withdraw, how much time do you need to get another attorney?
He's a court-appointed attorney, so I'm not sure.
Oh, he's court appointed?
Yes.
Yes, ma'am.
Oh, okay. I didn't know that.
I believe I'm his second lawyer.
Who was his first?
I don't recall, Judge.
I can't remember either.
Because I know when I met him in the courtroom, that had come up.
Let me check, Judge, real quick. Oh,
I believe it was Mr. Rene Vasquez, Judge.
Okay. What kind of bond does he have on a PR bond, Miss Chacon? Is it my bond?
I'm checking that right now. Judge, he does have a warrant. Yes, there is a warrant. Let's see.
Yeah, here it is. Let me.
This is the one, Judge, that Mr. Avelar had gotten a good rec for him, and then he came in at the end, and you admonished him, and then he has a warrant, and he hasn't turned himself in.
A warrant?
And then when he went to PR bond, they told him that he needed to turn himself in, and he said he wasn't going to.
Oh,
So, Judge, does the court want me to remind her?
Yes, please.
We had court, I don't know, a month and a half ago or so, Judge. And at that time, Judge, I believe Mr. Orozco was late. And so, he had apologized and, one thing or another, Judge. And then the court believed that Mr. Orozco was being less than forthright and quite rude. The court then ordered Mr. Orozco to turn himself in as a commitment. I believe it was a 6-day commitment or a 3-day commitment, something like that, Judge. Mr. Orozco refused. We then had a private conversation after that. And without getting into privilege,
Right.
One of the things I had said was, you need to follow the court's order. Let me know that he wasn't gonna do that. And we had a subsequent conversation because the warrant was still active. And here we are.
Okay. And Mr. Orozco continues to show attitude and disrespect to this court. Mr. Orozco, I don't want you to be late for work. What time do you have to be? Where do you work?
It's okay. I'm already late as it is. It's fine.
Where is it that you work, sir?
Instead of Valero's gas station on the west side.
Okay, sir. Which Valero's on the west side?
On where the Amazon festival.
Okay, sir. Sir, I'm gonna ask you to turn yourself in again.
And I'm sorry, I have a job. I have responsibilities out here. I mean, I know it's easy for you to ask me to do that, but it's not easy for me to do that.
This is the most intense point of the entire case. The court confirms there is an active warrant and brings back the defendant's earlier refusal to comply with surrender orders, making the situation far more serious. The attorney steps in to explain a breakdown in communication, but the judge makes it clear that continued non-compliance could lead to arrest without further warning. As pressure builds in the room, the defendant pushes back, insisting he hasn't done anything wrong, escalating the tension even further as the hearing reaches a critical stage.